Good afternoon. Hello, everyone. Welcome to the Arbitration channel and this special edition for Straight to the Point. It's a great pleasure to have you all here. We delve into International Arbitration Trends 2025 Brazil and US perspective. One of the most valuable contributions to our field comes from the team of Cleary Gottlieb, who's committed to analyze global arbitration trends, has been instrumental in shaping discussion and insights for practitioners worldwide. Their dedication produces the international arbitration trends. Reports offer us a unique perspective on key development challenges and opportunities. Today, we are honored to welcome three distinguished speakers who bring the analysis about this discussion. First, we have Milena Arbizu, partner of Demarest, who has built an outstanding career in international arbitration and dispute resolution, work with complex cross-border matters. Katie Gonzalez, associate at Cleary Gottlieb, whose practice focuses on international arbitration litigation involving Latin America. And finally, our moderator for today, Pedro Martini, associate at Cleary Gottlieb, who will be leading our discussion and guiding us through these trends. We invite you all to engage and ask questions in our chat. And thank you very much for you all. Thank you for Pedro to organize this and put this and make this happen. And thank you all to be here in Arbitration Channel. Pedro, the floor is yours. Thank you.
Thank you, Lauro. Thank you, Arbitration Channel, for offering us the opportunity to talk a little bit today. And thank you, Lauro, for the kind introduction of everyone. It's a great pleasure to be here with both Milena and Katie. And Milena is from a partner at Demarest, but she also worked with us at Cleary Gottlieb for 1 year some years ago, and was a tremendous pleasure to work with Milena when she was in New York. And of course, Katie is my colleague at Cleary Gottlieb in New York, and it's always a pleasure to be talking to her as well about different issues. So Milena, Katie, and I met, and we kind of came up with a more dynamic conversation today. And the idea is kind of to try to, each of us will raise an interesting issue that is hot and upcoming in especially for 2025, and then one of us will address that issue and the others will comment on that same issue, and then we can move to the next one. So we have a list of very interesting topics to be discussed today. We want to cover a little bit of more procedural arbitration issues that relate in particular to artificial intelligence in arbitration, anticipatory taking of evidence, and disclosures and conflicts of interest generally. We also are saving a little bit of time to talk about more substantive issues related to disputes that tend to go to arbitration, especially the topic of changes in circumstances, which we think is a very prominent topic today. And we have a special circumstance, I would say, this month with the commencement of the Trump administration, which creates a lot of questions about how what will be changing from now on in commercial relationships between U.S. and Brazilian parties, and how that will likely play out in disputes that go to arbitration. So let me first go to our first issue, and I think we had Milena had one question to ask to Katie, so that I will now pass the word to Milena so that she can start our discussion today. Thank you, Milena.
Thank you, Pedro. Just first of all, would like to thank Arbitration Channel, Lauro, Pedro, for the invitation to be part of this live session. It is a great pleasure to be here with you today. And as Pedro mentioned, we discussed a few topics, and one of the key trends that we identified for 2025 was the relationship between artificial intelligence and arbitration. And we know that over these past years, AI has evolved and presented major developments. Even this year, AI is already on the headlines of a lot of newspapers. Um, so it is definitely a sector that will impact the economy in various fields, and arbitration will not be an exception to that. So, having that in mind, Katie, um, could you share a bit on the insights you have about how AI is already impacting arbitration in the US, um, especially arbitration institutions and their rules?
Absolutely. And thank you, Milena, for the question. And thank you, of course, to Arbitration Channel and Lauro, and both Pedro and Milena for participating in this live chat today. I think, Milena, you teed up the issue really nicely in talking about some of the headlines that we've seen AI play a role in, even so far, just a few weeks into 2025, because artificial intelligence is such a headline grabbing issue. And I think it has the potential to have such a transformative impact on not just society, but also arbitration practice. And 2024 certainly saw an increased usage of AI, and institutions and practitioners asking themselves the question of how can we use AI and leverage these new tools in our arbitration proceedings and hopefully use them to fulfill the promise of arbitration as sort of an alternative form of dispute resolution that is efficient both in terms of time and cost. So to that end, in 2024, I think we saw a number of sort of new developments, both from institutions and organizations to try to leverage some of these efficiencies from artificial intelligence. For example, Jus Mundi launched an AI tool that synthesizes and summarizes some decisions in arbitration cases, which, as we all know, awards can be very lengthy. And this can certainly help practitioners sort of consolidate and better understand what publicly available awards have to say about certain issues. And institutions, especially in the United States, like the American Arbitration Association, have also sort of unveiled recently some AI tools to hopefully make the arbitration process more efficient, including the AI clause builder tool, which I think is intended to provide parties with an easier way of creating bespoke arbitration clauses that work for their contracts and their disputes, and has also recently rolled out a AAAI panelist search tool, which will allow case managers and parties alike to identify, using AI techniques, potential arbitrators to serve on their cases that sort of well match the needs of that particular case. But with seeing some of these tools that are being unveiled with respect to the arbitration process, I think there's a bunch of potential issues that artificial intelligence and the use of it in arbitration implicates. For example, in the United States, we've seen a few sort of headlines regarding hallucinations in various legal proceedings, which means that AI tools can sometimes fabricate a case or an outcome that can, of course, lead to unreliable results. And there's also been much talk about using AI in other ways to enhance efficiency. And so I think with using some AI tools in our practice, there's also been a sort of focus on how we can regulate the use of AI to make sure that parties and tribunals alike are making the proper disclosures and that it's not sort of having a negative impact on the arbitration process. And to that end, I think a lot of institutions and organizations in the United States have issued guidelines recently to try to provide parties with form clauses or sort of other procedural mechanisms or protocols they can use for AI in international arbitration. Like a few domestic arbitration institutions that come to mind are JAMS and the Silicon Valley Arbitration and Mediation Center, which have provided some guidance in the form of guidelines and rules to regulate the use of AI in arbitration. So that's what I think a lot of the US sort of based institutions are working on. And I'm curious, from your perspective, are Brazilian arbitration institutions doing the same, or are they following sort of a different path with respect to AI?
I feel that in Brazil, the arbitration institutions are still a bit behind in implementing guidelines in relation to AI. I can quote one example of the use of AI in arbitration institutions, which is a partnership between CCBC and Jus Mundi to publish arbitral awards, AI generated summaries of these arbitral awards. And this is being done to provide more transparency to the parties, and all trying to respect the confidentiality of the proceedings. But I think it's relevant to say that although arbitration institutions are still discussing the implementation of guidelines and rules, we can say that the Brazilian courts, the judicial courts, you can see a lot of discussion and implementation already of some of these tools. So, for example, the Brazilian Supreme Court has just implemented a system called Maria. The system is aimed at summarizing awards, providing reports of the lawsuits, helping in the analysis of the statement of claim. So you have already the Brazilian Supreme Court with an AI tool inside the court system. Another example is that recently the Brazilian Senate has approved a law regulating AI in general, not just focused on arbitration, but this law, if it's actually enacted, will have an impact in arbitration. And also the Brazilian National Justice Council has also enacted a rule authorizing the use of AI in the judiciary and in Brazilian courts, and it also establishes certain principles that should be observed. So, for example, these tools, they cannot discriminate on people. They have to have systems to ensure that AI will not do that. So it is interesting to see, I think, in Brazil that although arbitration institutions are still discussing, the Brazilian judiciary has already implemented and discussed these tools. One interesting case also, just to mention another example, is that there is before the Brazilian state court, a party filed an appeal claiming that the award should be annulled because when this party submitted the award to ChatGPT, ChatGPT stated that there was a medium to a high probability that this award was made with the use of AI. So this party claimed that because of that, the award should be annulled, and the São Paulo State Court decided that first there was not a definite proof of that, but also that the use of AI was already something that is accepted in Brazil, and that this should not be grounds for annulment of the award. So for me, this case is interesting because it shows the types of discussions we will have if we don't have clear rules. And I think we will also have these types of discussion in arbitration if we don't have a clear framework in relation to the use of AI and a clear consent of the parties to the use of AI. So in my view, at least, I think it's just a matter of time until Brazilian arbitration institutions, they already start to implement these guidelines.
Absolutely. Yeah, I think it's super interesting to hear the perspective of Brazil and to know that the judiciary seems to be very proactively sort of integrating some of these AI tools in its practice. But I do think, to your point, at least in the arbitration space, since arbitration is a creature of consent, there might be sort of additional considerations that the parties, need to, implement or at least discuss at the outset of their case. And many of the domestic arbitration rules and guidelines in the United States, which maybe at some point, could serve as a model, or at least be informative to some of the Brazilian institutions, do provide for certain protocols or certain clauses that can be integrated into a procedural arbitration clause that really provides the parameters of how parties, can use AI, and when they should disclose the use of AI, and how the tribunal can use AI. Because I do think there is a concern that, tribunals or parties might be using AI to, write or synthesize materials, and that does have a number of implications, especially relating to confidentiality, for example.
Yes, that's a very good point, Katie, because we got a question from the audience here in the comments. Felipe, who is watching us, asked whether there are any relevant discussions, or if we're aware of discussions on the use of artificial intelligence and the confidentiality of the arbitration. And I think you just touched on a very relevant point. I don't know if you have any insights based on what you saw so far about this issue.
Yeah, so to my knowledge, no cases yet have emerged, but I think, by virtue of the fact that there's at least this one in Brazil that Milena mentioned, it's probably just a matter of time, and it could even be 2025 in which we're seeing this. But there has been discussions in terms of whether AI can really be useful in the context of arbitration, primarily because, AI tools usually, are, large learning models, and they have to, have sort of precedents and examples, and it might be harder to find that in the arbitration space, where the parties prize confidentiality and the fact of non-disclosure of some of their, disputes and awards and the like. So I think, in some ways arbitration could be slower to embrace this by virtue of the fact that we do have this confidentiality concern, which could and should probably continue to animate discussions regarding the use of AI.
Yeah, very good. And if I can add, I do think that the Silicon Valley guidelines, I think that you mentioned, do have one guideline about confidentiality. Just Felipe, that's the one thing that comes to mind. I think it's guideline number 2 or something similar, where they say that of course, even if the parties are using artificial intelligence, they need to consider the needs to protect the confidentiality. And before using artificial intelligence, they should make sure that the tool will not result in a leak of that information, and thus protect confidentiality. And I think this is also valid not only for for arbitrators, but also to parties and counsel involved. Every time you use a tool that is linked to the cloud somehow, you may be sending relevant confidential information to the internet, to these databases, and you start risking breaching confidentiality. This can apply to not only like more advanced artificial intelligence tools, but even to simpler tools like translation tools that we have nowadays, which are also a form of artificial intelligence.
Yeah, and I think too, in addition to just perhaps this blanket concern of confidentiality of the proceedings, which might be embedded in the rules or agreed to by the parties, I think it also has the potential to have implications with respect to the maintenance of legal privileges, for example. At least in the United States, and I know this is a very jurisdiction-specific inquiry, but oftentimes in order to maintain privilege over certain communications or documents that are exchanged between counsel and client, there has to be sort of an expectation or an intention or maintenance of confidentiality between that group. And of course, if you are, filtering in something through AI tools, even if it's a translation tool, for example, you could potentially be risking your ability to claim privilege over something if it is somehow being disclosed or made public.
Perfect.
And
Milena, do you have anything else to add before we change topics? Yes, I just saw that you were.
yeah, I was just going to add that we're talking a lot about arbitration institutions and the guidelines that they may implement in relation to this topic, but also lawyers, they could implement any provision in relation to that in arbitration clauses. So especially when they're discussing a deal, to already have this concern in mind, because it is something that the parties can already try to establish the limits before the dispute arises.
Perfect. Completely agree. It's a very relevant point. So if I may, moving topics now, let me pick up on the topic that we're talking about potential rules that institutions may have to adopt and parties may have to adopt. And I think this relates to an update in Brazil, Milena. We've been seeing certain institutions in Brazil adopting what they call rules regarding the anticipatory taking of evidence, and that's not something that we've seen in U.S. institutions and in some other international institutions. And we thought it was a very interesting point that it may make sense to try to understand our non-Brazilian clients that do business in Brazil and may have arbitral institutions from Brazil involved, may be very curious about what that means. So what is that all about?
Yeah, so this is a topic that is very specific to Brazil. The anticipatory taking of evidence is a procedure to collect the evidence before the actual dispute starts. It's provided for on Article 381 of the Brazilian Code of Civil Procedure. And it basically aims this procedure to either preserve the evidence, so it serves as a precautionary measure, or even to facilitate a settlement or to help the party to determine if it will want to actually start the main dispute. So just by this definition, you can see that this type of procedure can be used in cases where there is an urgent requirement, but also in cases where urgency is not the main issue, but more the most important issue for the parties to define whether it wants to start the dispute or whether it wants to settle the case based on these documents. So in Brazil, based on this procedure established on our Civil Procedure Code, some parties, they file the anticipatory taking of evidence before the arbitration starts to define the strategy of the case. And there were a lot of decisions denying these requests under the argument that there was no urgency in that request. And since under Brazilian law, you can only file a judicial lawsuit if you have an arbitration clause in specific cases. And one of these cases would be if you have an urgency request, an urgency relief. The courts, they were interpreting that this anticipatory taking of evidence without urgency, they should be denied. Recently, the Brazilian Superior Court issued a decision on the matter. So it settled the discussion, stating that you cannot file for an anticipatory taking of evidence before judicial court. And if you have an arbitration clause, in the events that there is no urgency. So the parties that had an arbitration clause and wanted to collect evidence before the arbitration started, they were left in this arbitration limbo. And because of that, given this legal landscape, the arbitration institutions, they started to implement guidelines and to implement rules to have a specific proceeding to be administered by the arbitration institutions in relation to this anticipatory collection of evidence. So you have, just to name a few of the chambers, you have, for example, ANCHA, Fiesp, CCBC. They enacted rules in 2023, 2024, and CCBC just enacted in January of this year. So these rules, they are recent, and they mainly provide that this proceeding will be judged by one arbitrator, and this arbitrator will not be appointed in the subsequent main arbitration. So you have a separation of the person that will judge this collection of evidence and the arbitrator that will judge the main case. Moreover, another specific issue of these kinds of rules is that they provide for a proceeding that has less costs than a traditional arbitration. So the objective is to actually encourage the parties to use this proceeding before the arbitration institutions. And also, the arbitrator that is going to judge the case can only handle the case in terms of the production of the evidence. But this arbitrator cannot evaluate the legal consequences of the evidence that is being produced, or determine or issue any judgment on the merits. So the rules are also very clear in relation to that. So this is something that is very specific to Brazil, I feel. But as we discussed, I would be curious to hear from Katie how this works in the US, if it's possible to make any parallels in relation to the framework that I just explained, or if the parties, they actually don't resort to any similar proceeding in the US.
Sure. I apologize if my internet is a little bit spotty, but I'm happy to respond to that, and also would be curious to hear Pedro's thoughts, particularly as someone who has the background in Brazil, but also practices in the United States, to kind of bridge the gap between these two different traditions. In the United States, I think our policies with respect to discovery probably lead to a sort of a different outcome and understanding with respect to what might be available for parties and at what point in the procedures. Because typically in the United States, whether you're in litigation or even in arbitration to a lesser extent, there's going to be an understanding that discovery, the production of documents, typically in the context of an arbitration, is going to be something to which the parties will be entitled, during the arbitration process itself. So at least in my experience in the US practice, there isn't a lot of sort of anticipatory discovery or pre-dispute discovery that's permitted. I think it honestly typically happens in pretty narrow circumstances. Prior to 2022, there was a federal statute in the United States, 28 U.S.C. 1782, which we commonly refer to as 1782, that parties used to obtain discovery in the United States for use in foreign arbitration proceedings. But we had a sort of a landmark U.S. Supreme Court case, ZF Automotive v. Luxshare, which actually found that the statute couldn't be used in the context of international commercial arbitrations, because these are types of tribunals or bodies that aren't imbued with the governmental authority that Congress had in mind when they enacted the 1782 statute. But the Supreme Court in that decision left open the possibility that discovery could be used for international investment treaty arbitrations. But at least in the United States, we've seen a sort of constriction of that application in various decisions by U.S. district courts and courts of appeals in the United States recently. So generally, I think parties are resorting to more creative tools to the extent they want to obtain some type of pre-arbitration discovery. There might be mechanisms under state arbitration laws, for example, that parties can use. And oftentimes parties might use also sort of national transparency laws. In the United States, for example, we have the Freedom of Information Act that parties sometimes try to use up to obtain discovery. And I know different jurisdictions like Peru, for example, have similar laws that might permit some type of discovery in circumstances where the access to that information is warranted. But perhaps, Pedro, I don't know if you had any experiences that you could talk to with respect to obtaining discovery in the United States, kind of keeping in mind this Brazil perspective as well.
Yeah, I think you nailed it, which is an interesting contrast, right? The fact that Brazil has this proceeding that Milena described, where you can try to get evidence before the actual arbitration, but typically when you get into arbitration, the access to evidence held by the other party is more limited. It's the typical reference schedule that is present in international arbitrations. It's not as common in domestic arbitrations. So it's an interesting circumstance where in the US, because you do have the availability of reference schedules or similar requests for productions in the proceedings, then the only worry that you have is to make sure that the other side is on notice that they need to preserve documents. And this is a very common practice in the US when you are in a dispute with another party, or you anticipate that dispute, you send them a letter or a notice where you clearly state that you expect the party to preserve evidence that may be relevant to a future litigation. And by doing that, because of ethical rules applicable to lawyers and to parties, then you kind of safeguard it because all the evidence is just being reserved and saved. And when the time comes, you can just ask for that evidence for the arbitration. So there's no real major concern. And of course, if the party fails to preserve the evidence, then there are consequences for that behavior. But we do have some interesting different proceedings that may be available in very specific circumstances. So depending on the jurisdiction, we do know, for example, in Texas, there is a rule, the Rule 202, that allows a party to seek evidence before a dispute. And in Delaware, it's very common for corporate disputes to have what they call a books and records demand based on Section 220 of the Delaware Code, applicable to corporate issues, and the company has to produce that information, those documents. But it's interesting. I've seen at least one case where there was a corporate dispute with an arbitration clause, but before the arbitration actually started, the shareholder did use the 220 proceeding under Delaware law to seek books and records and kind of assess the strength of that shareholder's claims. So it's an interesting, it's something that is a little bit more similar, but it's very limited to corporate disputes, and only shareholders typically will have access to that kind of tool. So it's an interesting contrast, I think, between the US and Brazil. Okay, I think we can now move maybe to our next topic. I don't know. I think we had Milena raising another question for Katie. Milena.
Yeah. So the other topic that we selected to discuss today is in relation to disclosures and conflicts of interest of arbitrators. This is a topic that has been a trend already for the past years, but it's still something really, really relevant, and that is going to still be a trend, I think, for 2025. So actually, I just wanted to hear from Katie. Why do you think that this is still going to be an important trend in 2025 from a US perspective?
Definitely. I think it's going to be a trend, that continues into 2025 because, as our practice, as international arbitration becomes even more international, there is still sort of, I think, a lack of, convergence around what are the standards for assessing when arbitrators should make disclosures and what even constitutes conflicts of interest in certain cases. And we have seen some international bodies try to standardize these terms. For example, in 2024, the International Bar Association, or the IBA, released their sort of much anticipated revisions to the guidelines or the rules on conflicts of interest in international arbitration. It was the first time those rules had been revised in 10 years. And I think there was a lot of commentary that the revisions that were proposed were perhaps a little more modest than people expected, but at the same time incorporated, I think, some very important changes and modernizations to those rules to try to account for some of the recent and current day situations that we find ourselves in, particularly relating to sort of the advent of third-party funding and use of social media and issues like that that are really prevalent in arbitration these days. But even though we sort of have, perhaps a standard universal guideline, there's still a lot of uncertainty and divergence in terms of how courts in various jurisdictions sort of apply and assess these standards. And in the United States specifically, this issue was really brought to bear in a well-publicized number of cases in 2024. We had one case in the Second Circuit where a party had challenged an arbitration award on the basis that the arbitrator was biased because they had failed to disclose a potential conflict of interest. In this particular case, the conflict arose when one of the parties appointed arbitrators during the pendency of the arbitration was appointed to serve on a tribunal with the other side's counsel, and neither party had disclosed that. And the Second Circuit Court of Appeals in the United States that was reviewing whether the award should be vacated on this ground applied a test of actual bias, really looking at the totality of the circumstances and thinking whether a party could conclude that the arbitrator was actually biased against the other side as a result of this potential conflict of interest. And we saw in the same year a court in the 11th Circuit Court of Appeals also considering an issue of whether to vacate an arbitration award on the basis of arbitrator partiality or bias under the Federal Arbitration Act, which reached the same conclusion that it was not going to vacate the arbitration award, but sort of applying a slightly different test relating to the appearance of bias. That is, whether a reasonable person looking at all of the circumstances could conclude potentially, could think, could infer that the arbitrator was biased. And even though there were these two sort of slightly different standards in the United States, the Supreme Court declined to hear this case and sort of provide that guidance to the parties as to what was going to be the standard of review that courts looking at arbitration awards were going to apply. And I think as a result, in 2025, we're going to see a number of additional challenges sort of stemming from this uncertainty in terms of what constitutes conflicts of interest and what are the standards that courts apply in reviewing them at the post-award enforcement stage of proceedings. And by virtue of the fact that there are different courts in different parts of the United States that potentially apply different standards, I think there's also the possibility for gamesmanship among parties to make decisions as to where to go to enforce an award on the basis of courts potentially looking at different factors or applying different tests to that exact question. So I think all of these things together could certainly lead to some, additional discussions among the arbitration community. And just by virtue of the fact that, we have various international arbitration panels with people from different jurisdictions and different legal traditions sitting together and perhaps, looking at these standards from different lenses and applying them differently, much like courts even within the United States do. I think that could continue to lead to potential disputes and uncertainty among parties.
And Katie, do you feel, in light of this latest developments in your day-to-day practice already, that parties are more worried about this issue, or that arbitrators are disclosing more facts than they usually do? Do you feel any impacts on your day-to-day work?
Definitely. I think we see the practical impact of this almost, every time, we appoint an arbitrator in a case. I think first the parties are doing their diligence, potentially with these concerns that there could be a challenge to the award on the basis of arbitrator partiality in mind. And interestingly enough, the IBA rules actually do put an onus or an impetus on the parties to conduct their research and perform due diligence into any potential conflicts arising with the arbitrators that are appointed to serve in their cases. And at least in the United States, I do think there is certainly a trend for arbitrators almost over disclosing, because I think there might be a sense that, if they provide the parties with the information and the opportunity to make an objection or to seek disqualification or to raise an issue earlier on in the proceedings, that in some ways can help avoid the issues down the road in the post-enforcement phase, which I think can be a positive thing, but at the same time might have the effect of encouraging others in different jurisdictions that don't necessarily have that same sentiment about the potential challenge to arbitration awards. It might encourage them to be disclosing things that are not necessarily otherwise ordinarily disclosable. For example, being part of conferences or seeing people talk at events. I think these are sort of common aspects of the arbitration practice, but more and more we're seeing people disclose these, and I think it can create a large burden on arbitrators and counsel to keep track of these different issues. And I'm wondering, is it the same in Brazil? You're seeing sort of a resurgence of disclosures, or are people still sort of maintaining the regular type of disclosures?
My impression is that in Brazil is happening the same. That's also why I asked this question. We had a few awards that were annulled, and I think that made a lot of the practitioners worried about the limits and what kinds of facts should be disclosed by the arbitrator. There was also a lawsuit before the Brazilian Supreme Court questioning the burden on the arbitrator to disclose more facts, and actually asking the court to establish that the parties, they did not need to investigate everything, but that the arbitrator was obliged to disclose everything that was relevant. So we had all of these developments, which made the practitioners more worried about an annulment of the award because of some failure to disclose. And in my day-to-day practice, I can see that this has led to an over-disclosure, as you mentioned as well. And also the lawyers, they are doing more their research, which is a good thing. But still, you can see that these latest developments, they actually increased the burden on the parties to make sure that that everything is being disclosed, and to avoid any kind of arguments to annul the award afterwards.
Absolutely.
Yeah, it's an issue. If I may jump in and provide a couple of inputs here. Having seen disclosures in both countries, even if we disregard recent developments, I think in the U.S., the independent arbitrators and professional arbitrators already tended, like at least in my experience, in the few cases that I saw that happening, they tended to disclose a little bit more than in Brazil already. And I think it's an interesting perspective, because it really depends on what is the context of the specific community and the specific market that we're talking about. So if we're talking in Brazil about arbitrators that have 30, 40, 50 proceedings, for example, there is an increased risk of that arbitrator being involved in other proceedings with certain counsel, with certain arbitrators, with certain parties. And that arbitrator is the party with most knowledge as opposed to the parties. So maybe that arbitrator has to start checking a little bit of that information and making sure it's revealing. But at the same time, I completely understand the notion that a party can't just say, I'm not even doing any research, or just withhold information that the party learned early on in the process just to do a gotcha, later on in the process. So it's a tenuous, it's a very tenuous situation. There's a tension there, and I think there's no right answer or of more or less disclosure. But I do think that it may be interesting for the communities to try to see the different communities across across the world, to see how their practices differ from each other, because right now the best proxy that we have are the international guidelines, right? For example, the IBA guidelines that we have, and rules that apply internationally, that sometimes may have may be seen differently in different countries and may have different practical consequences in different countries. So the more we start to have this kind of conversation where we see how the practices are in each country, I think the more we may have to benefit to understand if there is a disconnect, if we're talking about different things. So like I can see a very clear practice in the domestic U.S. and the domestic Brazilian and the international context. So it's an interesting situation here. Okay, we don't have a lot of time left, and we have at least one topic still to address. And I think we had agreed to talk to a little bit more on the substantive issues, and we can briefly talk 5 minutes for each subtopic. I think we were going to discuss how arbitration, how in arbitration we may often see in the context of cross-border disputes in particular, we may see disputes about changes in circumstances. And I think a key hot topic at the moment is the many changes that may come with the Trump administration. And we know that Brazilians may have a lot of questions about that. I don't know, I think we had talked, Milena, do you have any questions that you think we could discuss that you want to raise for us today?
Yes, in relation to this topic of changes of circumstances, this month we had Trump's inauguration, and with that, a lot of discussions about the imposition of tariffs on other countries, and this will definitely impact commercial relationships and contracts. And as a consequence, this will also come probably with disputes in relation to these matters. So I would also like to hear from you, Pedro, if from your day-to-day practice, have you already seen as well any impacts? Are clients already worried about that? What kinds of questions are they asking in relation to this issue?
Yeah, that's a good point, Milena. And yes, we had questions by clients, and basically since the elections, Trump has been saying that he may increase tariffs to protect, the U.S. Industry and commerce. And it's very clear that from his first day, he already imposed higher tariffs on several countries. We saw tariffs increase in connection with Canada, Mexico. There's always the tension with China. So some of our clients have asked us, so what happens? What can I do if I have a contract right now, say for a supply of a certain product, to sell a product from Brazil to a United States client? What can I do if there is an increase in tariffs that I have under the contract the obligation to pay the tariff? So what can I do? And that's a very tricky situation because Brazilians, and Milena, I like to later hear your couple of thoughts on this, but in Brazil, we do have provisions, I think, under contract law in the general civil responsibility and civil liability, the possibility of revisiting and renegotiating contracts that are excessively onerous, for example. But that's not the case under most jurisdictions in the U.S., especially under New York law. And that is even when you have a force majeure clause in the agreement. So typically under New York law, if you have an event like a force majeure, you're talking about something that makes it impossible to perform, and therefore performance is excused. It doesn't mean that you are able to renegotiate a price and allocate a risk, reallocate a risk that had been previously with you to pay tariffs, for example, to the other party. So if there is an increase in tariffs and I am responsible for paying those tariffs under the contract, that is just a performance that it's a little bit more costly for me, and that's not really an impossibility to perform that would excuse my performance. So it's an interesting point to note and for clients to be aware of when negotiating contracts from now on. So for contracts up to now, if New York law is applicable, then a seller from Brazil that has to pay tariffs selling to U.S. clients, that seller may have very little possibility of getting anything to help that the Brazilian party to pay the tariffs. But moving forward, maybe what the party may want to negotiate is, do I want New York law applicable to my contract? And if I do want New York law, maybe I should have created a mechanism where if there is an increase of X% in the tariffs, we can have a formula where we change the way those tariffs are paid. So there are ways to put in the contract, but you have to put it very clearly in the contract. It doesn't, like I said, it's not enough to just say force majeure cover government acts, for example, because that typically will not be enough to renegotiate a contract. And it may not even be enough to just excuse performance depending on the change in tariff. If it's a 10% or 20% change in tariff, it would have to be something really high that would really make performance impossible for the party. And I don't know, Milena, if I properly portrayed Brazilian law here, and so you can say otherwise.
Yes, it's very interesting to hear the US perspective because it is different from the Brazilian one. We have more space to review the contract. On the other hand, considering the experience we had during the pandemic, although Brazilian law do allow for the contract to be reviewed in certain cases, what I saw during the pandemic was that the parties claimed they argued that a lot of different articles from the Brazilian Civil Code should be applied, and they presented them in a very imprecise way. So just to give a little bit of more color, in Brazil, we would have three main ways to discuss changes of circumstances: force majeure event, a burdensome event, or even a disproportion between the performances undertaken by the parties. Um, and we saw a lot of cases in which the parties they just used these three concepts and argued that the contract should be reviewed. In relation to judicial decisions, there were a lot of judicial decisions that applied these concepts in an imprecise way and actually reviewed the contract, even though the requirements they were not fulfilled. Um, so if I were to predict what would occur in Brazil if there was a high increase of tariffs, I can imagine the parties trying to argue into the use of these three concepts and trying to claim for a contract review. But despite the fact that each of these concepts they have their specific requirements, one discussion that is always important in these cases of changes of circumstances is how unforeseeable the event was to the parties at the moment that the contract was signed. So the timeline is always really important. So one thing is for a party to argue that the contract should be reviewed because of the tariffs, for example. If this contract was signed many years ago and there could not foresee that this tariff would be imposed. Um, Another case would be for a party to argue that, and this contract was signed last year when these discussions were already in the headlines, for example. An additional difficulty, I think, in the case of the tariffs is that you can expect that a government would change tariffs. It's not that unpredictable. So I think a party would really have to build and demonstrate why, on that specific case, the tariffs they were not foreseeable.
Absolutely. Thank you, Milena and Pedro. I think that's super interesting and sort of provides a nice pivot to perhaps our final topic, which is also very topical, as in it's been in the news very recently, and that relates to environmental issues. And perhaps, Milena, I could just ask you to very briefly summarize, because I know this could be a topic to which we could dedicate an entire hour, and we're almost out of time. But do you see environmental, issues, environmental impact, ESG continuing to be a hot button issue in 2025? And what might the, disputes look like in arbitration if we are to see them?
Yes, definitely, especially with environmental disasters being each day more common. And these disasters, they do affect commercial relationships and even proceedings. Um, so, for example, when we had the floods in Rio Grande do Sul here in Brazil, the deadlines of certain proceedings were affected. The parties had to discuss to postpone some of them because the parties they were located in that state where that suffered with those floods. Um, but also, I think in terms of the merits of possible dispute concerning these issues, I think the discussion would be similar to the one on the tariffs. The timeline of the relationship between the parties will be important, um, and you have to really see in the specific case if that event was foreseeable or not. And Katie, how do you see this issue developing in the U.S.?
Yeah, I think it's certainly another issue in the United States, both for the reason that you mentioned, when, natural disasters or environmental events impact the proceedings, but also I think from the substantive perspective, certainly I think parties are increasingly raising issues relating to environmental impact or remediation in arbitration proceedings, which is a little bit different, I think, in the United States, where, historically these might only be issues that come before regulators or that are subject to, litigation where there's perhaps more participation by the public. But I think increasingly it's impacting parties' commercial relationships, particularly as parties are increasingly memorializing environmental obligations in their contracts, including through, for example, HSSE provisions or various reps and warranties. I really do think 2025 is going to be a year in which we see environmental disputes continue to play a really significant impact in arbitrations.
Yeah, I agree.
Perfect. We've reached the end of our time for this amazing chat. I wish we had another hour to discuss. I think we underestimated how interesting and complex these issues are. But I think this was a good opportunity for us to kind of see the key hot topics that may come up this year, and maybe we can chat again in the beginning of 2026 to see if our predictions were right, what happened in 2025, and see what is to come in 2026 and coming years. Thank you, Milena. Thank you, Katie. It has been a pleasure to chat about all these issues with you, and thank you, Arbitration Channel, for the opportunity. And I hope we get to chat again about these various interesting issues.
Thank you all.
Thank you.
Goodbye.
Okay.
Bye.
Bye
Thank
bye.
you.